This video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments in the justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only. Hey, Jamie Carper here. Today's case is about war, terrorism, executive power, and a reminder that even in the most dangerous moments, the Constitution does not quietly leave the room. The case is Hamdan versus Rumsfeld, 548 U.S. 557-2006. Here's the background: tight, accurate, no hype. Salim Ahmed Hamdan was captured during military operations in Afghanistan and transferred to Guantanamo Bay. The U.S. government alleged that he worked as a driver for Osama bin Laden. He was designated an enemy combatant. Instead of trying Hamdan in a regular federal court or a court-martial, President George W. Bush authorized military commissions created by executive order to try certain detainees for war crimes. Hamdan challenged those commissions. Now lower courts. A federal district court ruled in Hamdan's favor, holding that the military commission system violated both the Uniform Code of Military Justice, UCMJ, and the Geneva Conventions. The D.C. Circuit reversed, siding with the government. It held that the president had authority to create the commissions and that the Geneva Conventions were not judicially enforceable by Hamdan. So the case lands at the Supreme Court. Here are the issues before the court. Does the president have authority without congressional approval to create these military commissions? Do the commissions comply with the UCMJ? Does the Geneva Convention's Common Article 3 apply to detainees like Hamdan? And, hovering over everything, what limits exist on executive power during wartime? This is not a small case.
We'll hear argument in Hamdan versus Rumsfeld.
Justice Stevens, and may it please the court. The President, as Commander-in-Chief, has authority to convene military commissions to try enemy combatants. These commissions are a traditional and necessary incident of war.
And Congress hasn't said no.
Correct, Justice Scalia. And through the authorization for use of military force, Congress has implicitly approved the President's actions.
But the UCMJ sets rules for military commissions. Why don't those rules apply here?
The commissions are adapted to the realities of modern warfare. Full court-martial procedures are impracticable.
Impracticable or inconvenient?
Impracticable, Justice Breyer. National security requires flexibility.
What about the Geneva Conventions?
They do not apply to this conflict, and even if they did, they are not enforceable in court by detainees.
Counsel for Petitioner.
Justice Stevens, and may it please the court. The President does not have unchecked authority to create tribunals that violate statutes enacted by Congress and binding international law.
Let's start with the UCMJ.
The commissions depart from court-martial procedures without showing the necessity required by the statute. That violates the UCMJ.
And the Geneva Conventions?
Common Article 3 applies to all armed conflicts not of an international character. It guarantees basic protections, including trial by a regularly constituted court with fundamental fairness.
So your position is that these commissions fail that test?
Yes. They allow exclusion of the defendant from evidence and lack the guarantees required by law.
Thank you, counsel. This case is about separation of powers. The President must follow laws Congress has enacted even in wartime. The Commander-in-Chief must have flexibility. Courts should not micromanage war. Flexibility does not mean lawlessness. The UCMJ applies unless Congress clearly authorizes deviation. Congress knows how to authorize commissions. If the President wants different rules, Congress can say so. And Common Article 3 provides a minimum baseline, a regularly constituted court with essential judicial guarantees.
This court lacks competence in wartime judgments.
But we are competent to say whether statutes and treaties are being followed. The commissions fail under the UCMJ and violate Common Article 3. That's enough. This invites judicial intrusion into military affairs. Or it enforces the rule of law precisely when it matters most. The Constitution does not turn off during war. The court holds that the military commissions convened to try Salim Ahmed Hamdan lack authorization from Congress and violate both the Uniform Code of Military Justice and Common Article 3 of the Geneva Conventions. The executive is bound to comply with the rule of law that governs armed conflict. I respectfully dissent. Today's decision improperly inserts the judiciary into the conduct of war. The Constitution assigns wartime authority to the political branches, especially the President as Commander-in-Chief. History shows that military commissions have long been used to try enemy combatants without prior congressional approval. Congress did not prohibit these commissions. Through the authorization for use of military force, it empowered the President to prosecute the war against al-Qaeda. The court's demand that these commissions mirror courts-martial misunderstands their purpose and ignores wartime realities. The court further errs by relying on Common Article 3 of the Geneva Conventions, which was never meant to govern conflicts with transnational terrorist organizations and is not judicially enforceable absent congressional action.
I join the dissent. The court lacks institutional competence to second-guess national security decisions. War is not governed by judicial micromanagement. By imposing its own rules, the court weakens the executive's ability to protect the nation and disrupts the separation of powers.
The Constitution does not require this result. The President acted within his authority, and the military commissions should be upheld. I respectfully dissent.
Here's the holding straight and serious. The President does not have unilateral authority to create military commissions that violate statutes enacted by Congress or the minimum protections of the Geneva Conventions. That's Hamdan versus Rumsfeld. Why is this case important? Because it says that war does not erase the law. Because it reinforces separation of powers, Congress writes the rules, even for war. And because it confirms that Common Article 3 of the Geneva Conventions applies to detainees like Hamdan. This case forced the political branches to go back to Congress, which they did with the Military Commissions Act. But the court made something crystal clear first. Even in the fight against terrorism, the President is not above the law. I'm Jamie Carper. And remember, constitutional limits matter most when power is strongest and fear is highest.